The subcommittee on capital markets will come to order. Without objection, the chair is authorized to declare recess of the committee. This hearing is entitled SEC Enforcement: Balancing Deterrence with Due Process. Without objection, all members will have 5 legislative days within which to submit extraneous materials to the chair for inclusion in the record. I now recognize myself for 5 minutes to give an opening statement. I'd like to thank you all for joining us this morning. During today's hearing, we will examine ways to improve the Securities and Exchange Commission's, the SEC's, enforcement function, which must strike the right balance between deterring and punishing securities fraud, preserving due process rights, and protecting the interests of those who rely on our markets to invest and save for their retirement. To ensure that our markets remain the envy of the world, it is critical that the Enforcement Division gets this balance right. Since 1972, the division has been responsible for investigating and prosecuting violations of the federal securities laws, both in federal court and in proceedings before administrative law judges. Its efforts to deter and punish wrongdoing are designed to help the Commission protect investors and maintain fair, orderly, and efficient markets. The same efforts should instill confidence in our markets and encourage everyday Americans to safely invest and save for their retirement. Our capital markets benefit from an enforcement division that is equipped with the tools to detect, punish, and prevent fraud. But the division's current trend of regulation by enforcement harms market participants, specifically by implementing policy changes that are not subject to the Administrative Procedures Act notice and comment requirements. We will also explore how proceedings before administrative law judges may infringe on due process rights and how the division's gag rule may restrict free speech. I want to be clear. Our goal is not to restrict access to important investigative tools. Instead, our goal is to protect the due process rights of all market participants, increase accountability and transparency, and enhance public trust. Under Chair Gensler's heavy-handed leadership at the SEC, these goals are now as important as they have ever been in the agency's roughly 90-year history. Even the SEC's own Director of Enforcement has recognized their importance. In a speech before the New York City Bar Association Compliance Institute last year, Director Graywall conceded that, and I quote, "Public trust in our institutions is faltering." Based on the Commission's recent actions, however, the public's trust in the SEC will decline further if the problems we highlight today aren't addressed. For example, public trust in the SEC will only decline when its employees are sanctioned and forced to resign for their, quote, gross abuse of power, as they were in the recent case against the crypto platform known as DebtBox. During that case, SEC attorneys made false statements and misrepresentations against defendants in court. These actions are extremely concerning to members of this committee who recognize that cases should never be handled in such an unethical and unprofessional manner. Likewise, public trust in the SEC will only decline when its staff pursue, quote, shadow trading enforcement actions or engage in off-channel communications sweeps that consider each of a company's unarchived WhatsApp messages as a separate violation of the securities law. Finally, public trust will falter and decline when market participants cannot share truthful information to their settlements, related to their settlements, or when SEC staff act as both the prosecutor and the judge in cases seeking millions of dollars in penalties. The areas we intend to focus on today involve matters of fairness, transparency, accountability, and trust. Every member of this committee should be concerned when market participants lose confidence in their regulator, especially when that regulator's job is to instill faith in our markets. I'd like to thank, again, our witnesses for their testimony, and I look forward to our discussion here today. The chair now recognizes the ranking member of the Subcommittee on Capital Markets, the gentleman from California, Mr. Sherman, for 4 minutes for an opening statement.
Next week is Law Enforcement Week, and we will honor those who fight for crime in the streets. It is entirely appropriate that we have this subcommittee hearing to honor those who fight crime in the suites. There were 2 SEC lawyers who acted wrongfully in the debt box case. They've been fired, and I think that sets an example that will assure that other SEC lawyers do not act similarly. A disproportion of the SEC's enforcement actions are against the crypto industry. That's not a coincidence. As I said when Sam Bankman-Fried was indicted, the crypto industry will tell us that Sam Bankman-Fried is a single snake in a garden of crypto Eden, when in fact crypto is a garden of snakes. Recent SEC actions illustrate that. Without objection, I'd like to enter into the record this article in Politico. SEC's Gensler turns tide against crypto in courts. In particular, the SEC has gone after the crypto exchanges. We had a hearing on this a little less than 2 years ago. I was sitting in that seat over there, and I hammered home the fact that it's not enough to go after the crypto. You have to go after the illegal securities exchanges, and the SEC has begun to do just that. I would like to see Americans invest in the stock of companies that create a product or service for American consumers, rather than this ephemeral effort to create a currency that would rival the dollar or other national currencies. The SEC has a $2.1 billion budget. $676 million of that is on enforcement. The SEC's enforcement division secured almost $5 billion. Of that, $3.4 billion went back to investors, and $1.5 billion or so went to the government. But the purpose of SEC's enforcement action isn't to secure fines or even restitution. The main purpose is to deter action, and for everyone who's caught, there are dozens who thought of doing something wrongful and then thought better of it. Now, I would prefer that the SEC issue comprehensive regulations so that everybody knows what the law is in every instance. The main opposition to that comes from the crypto industry, which has fought tooth and nail any meaningful regulation in an effort to give itself just a patina of regulation. The SEC ought to, by Congress, be given absolute and clear jurisdiction over crypto, because that is the agency that's proven itself for almost 100 years to be the best agency to regulate investment assets that are intangible. We have extensive safeguards at the SEC dealing with prosecutorial malpractice. The commissioners themselves have to approve investment action. Most importantly, this is enforcement action through the courts. It's entirely appropriate that the SEC has brought enforcement action against crypto, and especially against DebtBox, because DebtBox was clearly a security. They throw the red herring out that, well, they're part of the crypto world, and there's disputes as to whether certain tokens are securities. But as the Howey case demonstrated, nobody claims that an orange is security, but an investment contract where you profit from the work of others in developing a orange grove is a security, and clearly the SEC acted appropriately in bringing this action. The SEC has received 18,000 tips, a 50% increase over the prior year. Last year, whistleblowers received $600 million. We need whistleblowers, and I yield back.
The gentleman yields back, and while we wait for the ranking member, I think we'll move on to our testimony today. We welcome the testimony of Professor Paul Eckert. Professor Eckert is a professor of the practice of law at the College of William and Mary Law School. Mr. Nick Morgan. Mr. Morgan is the president and founder of the Investor Choice Advocates Network. Mr. Andrew Vulmer. Mr. Vulmer is a senior affiliated scholar at the Mercatus Center and former SEC Deputy General Counsel. Mr. John Reed Stark. Mr. Stark is the president of John Reed Stark Consulting and former chief of the SEC Office of Internet Enforcement. We thank each of you for taking the time to be here. Each of you will be recognized for 5 minutes to give an oral presentation of your testimony, and without objection, each of your written statements will be made part of the record. Professor Eckert, you are now recognized for 5 minutes to give your oral remarks.
Chairwoman Wagner, Ranking Member Sherman, and members of the subcommittee, it is indeed an honor to be here today. For more than 2 decades, I represented clients in SEC investigations. I retired from the private practice of law in 2022 and joined the faculty at my alma mater at William & Mary School of Law in Virginia, where I continue to teach and study securities regulation. The views I express today are solely my own and not those of my former law firm or my current employer. I believe that well-regulated securities markets are critical to our success as a nation. The SEC and its Division of Enforcement have safeguarded those markets for decades. Last year, the division initiated nearly 1,000 investigations and oversaw an existing portfolio of nearly 1,400 matters. Their work is crucial, and by any measure over the years, they've done exceedingly well. Yet, opportunities for improvement surely exist, and this committee is right to examine possible reforms. The SEC has never in its history had the luxury to rest on its laurels or the improvidence to suggest that its practices cannot be improved. And it is with this spirit in mind that I'll highlight 3 points from my written testimony. First, delays in SEC investigations remain a persistent challenge, and the SEC should restore a 2-year goal for the completion of investigations. Until recently, the SEC had a performance goal of filing enforcement actions within 2 years of opening an investigation. There are good reasons for this, and the SEC has repeatedly acknowledged them, and I detail them in my written statement. Yet since at least 2016, only about half of enforcement actions have been filed or closed within 2 years. These figures are especially disappointing when one considers that about 1/3 of all enforcement actions are either so-called follow-on administrative proceedings or delinquent filings matters for which no investigative or little investigative effort is required. Second, I believe that reforms to SEC disqualification waiver procedures would allow for a more principled and predictable process. There are a variety, as you know, of automatic disqualifications, some of them quite serious, that may arise from enforcement actions brought by the SEC and other state and federal regulatory authorities. Firms must assess the need for relief from these disqualifications when negotiating settlements. And without weighing in on the merits of whether a waiver should be granted in any particular circumstance, I believe that there are 3 process reforms that would be helpful. First, restoration of the SEC's policy of allowing a settling entity to request that the Commission consider an offer of settlement of the underlying enforcement action combined with related waiver applications. The Commission would in no way be committed to approving a waiver application, but this mechanism would avoid the need for a chaotic exit of a business line or the need for emergency relief to safeguard existing clients and investors. Second, for enforcement actions in which the SEC is itself a party and has imposed sanctions it believes fully address the misconduct, I believe there should be a presumption that no further disqualification is necessary. And finally, I believe that the procedures already implemented by the SEC for waivers on Regulation D disqualification should be codified and extended to 3 other disqualifications. This would allow state AGs and other state and federal authorities to state in settlement papers their conclusion, if they reach one, that further disqualification is neither intended or necessary. And finally, I believe that respondents in SEC administrative enforcement proceedings seeking fines and other sanctions should have a federal removal right. As penalties and sanctions permitted in administrative proceedings have become both more severe and more common, we ought to reconsider the fairness of allowing the SEC to rely on a forum that does not have the same procedural protections that Americans have come to expect in other types of governmental actions. In my written testimony, I do identify 3 categories of more traditional administrative proceedings that, in my view, don't present the same concerns. Those are proceedings related to stop orders, delinquent filings, and temporary trading halts. Thank you very much, and I look forward to your questions.
Thank you, Mr. Eckert. Mr. Morgan, you are now recognized for 5 minutes for your oral remarks.
Thank you, Chair Wagner, Ranking Member Sherman, and distinguished members of the Subcommittee on Capital Markets. My name is Nick Morgan, and I am the founder and president of Investor Choice Advocates Network, or ICANN. ICANN provides pro bono representation to small investors and entrepreneurs who could not otherwise afford counsel in SEC proceedings. I appreciate the opportunity to provide some observations about the way the SEC enforces the federal securities laws. From my years as senior trial counsel at the SEC in the Los Angeles office, I appreciate the importance of the SEC's mission to protect investors. From my years as a partner in the securities enforcement practices of 2 different multinational law firms, I gained further perspective, which led me to found ICANN, leave my law firm partnership, and devote myself to serving people who are facing SEC enforcement proceedings but who cannot afford counsel. I will discuss what is often referred to as regulation by enforcement, changes in policy on a piecemeal, case-by-case basis without the transparency and public input that accompany rulemaking and other methods. However, I will address regulation by enforcement through the experience of 2 ordinary people not accused of fraud or of harming investors, ICANN's clients, Eric and Joseph. Eric's encounter with the SEC began over 10 years ago and is a story of an average financial services professional whose life has been destroyed after he inadvertently ran afoul of the SEC while simply doing his job. To understand how regulation by enforcement has impacted Eric's life, we first have to go back more than 30 years at a time, decades before the SEC sued Eric, when a new financial instrument was becoming popular. At the time, in 2012, the DC Circuit Court of Appeals determined the SEC did not have jurisdiction over this financial instrument. Case closed. But the beauty of regulation by enforcement from the SEC's perspective is that if one court, even a court as distinguished and important as the DC Circuit Court of Appeals, tells you that you do not have jurisdiction, you can simply shop your policy around at different forums, even for decades, until you find a judge who agrees with you. And that's what the SEC did with Eric years later. Flash forward to 2014, when Eric worked as a sales agent for a company selling the same financial instrument. After a lengthy investigation, the SEC sued Eric in federal court in Los Angeles, asserting jurisdiction over the instruments, alleging that the instruments should have been registered under the federal securities laws. Acknowledging that Eric did not act with fraudulent intent and acknowledging the 30-year-old ruling from the DC Circuit, the federal court in Los Angeles nevertheless found Eric liable for non-fraud registration violations, entered a permanent injunction against him, and ordered Eric to pay $250,000 in disgorgement and penalties. As a 60-year-old whose career and employment prospects had been decimated by his years-long litigation with the SEC, Eric did not have the means to pay even a fraction of that amount. Moreover, the federal court injunction caused Eric to be designated a quote-unquote bad actor and prompted the SEC to start an entirely new administrative proceeding seeking to permanently bar him from the securities industry. Eric had little choice but to appeal. That appeal is pending. Joseph is a Los Angeles entrepreneur who set out in 2014 to create a production studio that would provide film and television content for an underserved, diverse urban audience. When in 2016, the Obama administration announced the Jobs Act, Joseph was one of the first entrepreneurs to seize the chance to grow his business while giving members of his community the opportunity to put their money to work as investors. Then the SEC got involved. Because of an unintentional violation of an SEC registration requirement, the regulator threw the book at him without ever alleging that Joseph or his company had committed any type of fraud, harmed any investors, or misused investor funds. The SEC ultimately took Joseph to federal court in Los Angeles. In Joseph's case, the issue of regulation by enforcement arises in the way the SEC pursues disgorgement in the absence of investor harm. Recently, courts, including the United States Supreme Court, have been critical of the SEC's usual approach to disgorgement, particularly in cases like Joseph's, in which the SEC does not allege or prove any investors suffered financial harm. In fact, last year, the Second Circuit Court of Appeals specifically ruled against the SEC when it requested disgorgement from a defendant who had not caused any pecuniary harm to investors. But Joseph lives in Los Angeles rather than within the Second Circuit, so the SEC has taken the position that it remains free to ask the court to impose a judgment requiring Joseph and his company to pay $1.2 million in disgorgement, even though the SEC never alleged investor harm in its complaint and never presented any evidence of investor harm during the case. Rather than developing a uniform policy with regard to disgorgement in non-financial harm cases through rulemaking or other methods, the SEC is addressing the issue through piecemeal litigation on a case-by-case basis where it is free to ignore adverse rulings in some jurisdictions to seek more favorable results in other jurisdictions. Among many problems, the SEC's regulation by enforcement policy causes legal uncertainty for ordinary people, including people not accused of fraud who are forced to litigate policy matters on a case-by-case basis, even when a federal appellate court rules against the SEC on a particular policy. Thank you, and I welcome any questions.
Thank you, Mr. Morgan. Mr. Vulmer, you are now recognized for 5 minutes for your oral remarks.
Chair Wagner, Ranking Member Sherman, and members of the subcommittee. The SEC enforcement process has much to commend it, but it also suffers from serious flaws. My written statement describes several general problems with the system and talks about 3 specific areas. The first is that the statutes do not set a workable standard for determining civil monetary penalty amounts, and neither the courts nor the SEC has interpreted the law to set consistent and predictable legal standards. As a result, the SEC and courts have nearly total and unreviewable discretion to set penalty amounts. This is especially true in settlements, where, as a practical matter, the SEC enforcement staff, rather than the commissioners, set the amount of the penalties. The area is lawless. That means penalty amounts are often excessive, unpredictable, inconsistent, and disproportionate to a reasonable assessment of the severity of a violation. The second topic my written statement talks about is confusion created by the new disgorgement statute, which gives federal courts the authority to award disgorgement in SEC enforcement cases. A key question the statute created is whether disgorgement, as authorized by the new statute, must abide by equitable limitations the Supreme Court described in a case called Liu versus SEC. The federal courts have already split on that question, and in particular, whether disgorgement may be ordered if distributing the proceeds to injured investors is not possible or not cost-effective. Congress should enact clarifying amendments to prevent the delay, uncertainty, and inconsistency that will occur if the questions are left to the courts. The third topic I address is the use of administrative proceedings at the SEC to establish liability and sanctions for violations of law. Although the SEC has paused the use of what I call APs, administrative proceedings, in litigated enforcement cases for the past few years. The Supreme Court is reviewing constitutional questions in this area and is expected to rule soon. But if the court permits APs to continue, Congress should act. The main problem is that the procedures for APs at the Securities and Exchange Commission are biased against the defendant. Defendants do not receive the kind of even-handed, independent treatment that they receive in federal court. This is true for several reasons, starting with the lack of independence of the decision makers, who are either SEC administrative law judges or the commissioners themselves. The best solution would be to eliminate APs and require the use of federal courts for all SEC enforcement matters. An alternative would be to give a defendant the unqualified and unreviewable right to move an AP to federal court. When you step back and assess the SEC enforcement process as a whole, you see it needs reform. In short, the SEC enforcement process over-deters beneficial capital markets activity. Congress should initiate a complete review of the process by an independent group of experts. I look forward to your questions.
I thank you, Mr. Vulmer, and we now turn to Mr. Reed Stark. You're recognized for 5 minutes, sir, for your oral remarks.
Chairman Wagner, Ranking Member Sherman, and members of the committee, it is my honor and privilege to sit before you today. Thank you for inviting me to testify. Some catchphrases are awesome, like "May the Force be with you." Some catchphrases are hilarious, like "More cowbell." And some catchphrases are baseless and misleading, like Theranos' mantra that one tiny drop changes everything. The catchphrase of SEC regulation by enforcement, which I predict you will hear over and over again today, falls squarely into that last category, just plain false. Today I want to focus my remarks specifically on the digital asset industry. I do this both because crypto promoters represent the most important recent example of industry players accusing the SEC of unfairly policing the markets, and also because in all my years, I've never witnessed such a well-funded, coordinated, and unfounded assault on the SEC and its mission. Along these lines, the digital asset industry claims that by failing to provide fair notice of SEC rules to the cryptoverse, the SEC consistently violates due process rights of legitimate crypto financiers, and that the SEC is a rogue regulatory outlaw engaged in a self-serving, politically motivated power grab, stifling innovation, and impeding investor empowerment. Remarkably, even after the debacles of FTX, BlockFi, Celsius, Terraform, Voyager, and so many other crypto failures, the digital asset industry continues to repeat these talking points in the vain hope that the more they say it, the more people will believe it. But what the digital asset industry calls SEC regulation by enforcement, the rest of us simply call enforcing the law. Since 1934, the SEC Enforcement Division has addressed emerging issues with common sense and flexibility, and without the benefit or hindrance of detailed prescriptions, including for policing foreign bribery payments, municipal securities fraud, derivative scam, unlawful insider trading, fictional prime bank instruments, subprime grifts, eel farms, ostrich farms, orange groves, the list goes on and on. So-called digital asset investors are betting on the efforts of the promoters and originators of these digital assets. That triggers the 33 Act. So-called digital asset firms have co-opted the nomenclature of the securities industry, calling themselves exchanges and brokers and market makers, creating a counterfeit veneer of investment-related assurances, integrity, expertise, and regulatory supervision. That triggers the 34 Act. The SEC Enforcement Division has had no choice but to act in the face of this conduct. Without the SEC's vigorous enforcement, these digital financial behemoths will continue to operate in the shadows with no transparency, no consumer protections, and no accountability. The bottom line is this: the sole federal regulator charged by Congress to determine what is a security and enforce rules meant to protect investors has determined through successive commissions led by Republican and Democratic chairs that nearly all crypto offerings are securities, and the courts have agreed with the SEC's analysis time and time again. Meanwhile, the promoters of digital assets claim to be champions of a digitally transformative technological revolution that is the future of finance and the future of money. Yet in an oddly hypocritical twist, when the SEC comes knocking, they argue in court papers that selling digital assets is just like selling baseball cards, American Girl dolls, or Beanie Babies. Digital assets typically have no cash flow, no yield, no employees, no management, no balance sheet, no product, no service, no history of operations, no earnings reports, no proven track record of adoption or reliance, and that list goes on too. How can any financial analyst, let alone any everyday investor, conduct a proper valuation amid such a boundless data vacuum? This is the real reason why it's difficult for the issuers and intermediaries of these digital assets to register. They would be forced to answer tough questions about why investors should invest in those securities and forced to allow the SEC to examine, inspect, and audit their books, records, and operations. Don't get me wrong, the SEC is far from perfect. There are SEC cases and SEC rules that I believe are unfair, and I agree that SEC respondents should have a right of removal from SEC administrative courts. But on balance, the SEC is a remarkably successful regulatory agency, and by enforcing its effective, proven, and evolving U.S. securities law framework, be it in the cryptoverse or elsewhere, the SEC has not gone rogue, but is simply just doing its job. Of course, digital asset advocates may not like the outcome of SEC enforcement policing, but that doesn't amount to an absence of due process and fair notice. It just means that the asset industry needs to get its act together and adapt to the laws that apply to it, not the other way around. Thank you.
Thank you, Mr. Reed-Stark. The chair now recognizes the gentlelady from California and the ranking member of the full committee, Ms. Waters, for 1 minute.
Thank you, Chair Wagner and Ranking Member Sherman. Defunding or defanging the SEC only empowers fraudsters, grifters, and those who know the law but don't like it. Among these are many crypto firms. To date, the SEC, under both Democratic and Republican chairs, has taken over 170 enforcement actions against crypto bad actors. The crypto industry, which publicly claims to want regulation, is suing the SEC for trying to regulate it. Despite the fact that the courts agree that the laws on the books are applicable, crypto can't have it both ways. We need strong protections, not deregulation. My message to the crypto industry and everyone else: Democrats will always press for compliance, investor protection, and market integrity. We're going to have a bill on the floor on Wednesday, another attempt to kill off the SEC on SOB 121, where they're simply trying to follow the guidance of the SEC as it relates to disclosure and what to do on the balance sheet. I yield back.
Gentlelady's time has expired. We'll now turn to member questions, and I recognize myself for 5 minutes for questioning. Mr. Morgan, I've been impressed with many of the amicus briefs you've authored in response to cases of SEC overreach. I'd like to start by briefly discussing 2 of them with you today. First, in the Jarkizi case, you filed a brief with Elon Musk and Mark Cuban, arguing that the SEC's cases before administrative law judges raise serious constitutional and fairness concerns. Would you elaborate on what those concerns were and explain why the SEC should funnel more cases to the federal courts?
Certainly, Chair Wagner, and thank you for the question. The Jarkizi case is, of course, the case that Mr. Vulmer referred to that is currently pending in the Supreme Court. And the issue in that case is whether, there are several issues. The issue we focused on is whether respondents in SEC administrative proceedings are entitled to a jury, which we think they are. The increased use of juries by the SEC followed Dodd-Frank, but since then there have been a number of Supreme Court cases that have called into question the propriety. The bottom line is, Chair Wagner, the respondents don't get the benefit of a jury trial. They're either, when they're in an administrative proceeding, they're either presided over by the commission itself or by administrative law judges. And these are in cases where the SEC is seeking penalties. So they're entitled to a jury trial, and that's what's at issue in that case.
And in the interest of time, in the Romero case, you filed another brief with Elon Musk and Mark Cuban, this time raising First Amendment and due process concerns with the SEC's so-called gag rule. Would you explain why the gag rule is problematic, and should the SEC get rid of the gag rule?
Certainly. So the gag rule prevents defendants from saying anything that contradicts the SEC's allegations and their complaints. The problem, there are many problems with that. The First Amendment problems were raised by Mr. Romero himself. In our brief, we raised an additional problem, which is the markets, the SEC would presumably be the first to acknowledge, are entitled to transparency. If there is information that shareholders should know about that's contrary to what's in the SEC's complaint, the SEC should be insisting on full transparency. The FTC doesn't require these gag orders. It's just the SEC. There's really nothing for them to be afraid of.
No way to defend yourself. Mr. Vulmer, in an article last year, you wrote that, I quote, in fiscal year 2022, the SEC brought 462 enforcement cases that ordered total penalties of $4.2 billion. That, sir, is over $9 million on average for each case. Mr. Vulmer, can you explain how that is possible when the governing statutes provide a maximum penalty of $11,000 to a $1.1 million per violation? Is the SEC staff simply ignoring these statutes? And what steps can Congress take to fix this problem?
Chair Wagner. Excessive penalties are a problem because of ambiguous statutory language. So each of those maximum penalty amounts connect to the word violation. And so it's all, how do you define a violation? And that's why I say there are no predictable and consistent rules, because the courts haven't established a rule and the SEC hasn't established a rule. So courts and the SEC are free to set penalty amounts. And it's particularly a problem in settlements. As you know, nearly all SEC enforcement cases settle, and with no adequate standard about how to define a violation, the staff is completely free to set within its own discretion a penalty amount. That's why you have these massive penalties that are disproportionate to the severity of violations. Congress should amend the language of the penalty statutes. And one of the bills you have
Yes.
as a draft language.
Good, and we plan to do that. Mr. Eckert, in her remarks at the SEC Speaks on April 2nd, 2024, Commissioner Peirce stated that the Commission's quick draw of its enforcement guns should concern anyone who cares about this great institution and the amazing markets that we regulate. I share Commissioner Peirce's concerns. Mr. Eckert, would you explain why the SEC's quick draw of its enforcement guns is so problematic?
Well, I believe there are times, and this is what I think the comment referred to, when the SEC seems to undervalue the non-enforcement alternatives that are at their disposal, deficiency letters, interpretive guidance, 21A reports, or simply informal staff guidance. These things can have a more immediate and wider impact than one-off enforcement actions at times.
My time has expired, and I thank you. The chair now recognizes the distinguished ranking member, Mr. Sherman, for 5 minutes for his questions.
First, I'd like to turn to this list of legislation that we're presumably dealing with in this hearing and point out that first of all, the vast majority of these bills are unipartisan. And second, most of them have little to do with this hearing. I guess you can call a hearing enforcement and then say any substantive rule that the SEC is thinking of doing needs to be enforced. But this hearing is about the enforcement process, not about the substantive rules. So if the majority believes that before we consider a bill, we should have a hearing about a bill, I look forward to a hearing that focuses on these bills. Mr. Vulmer says that we are over-deterring beneficial actions. I think we're under-deterring wrongful actions. And there's no greater focus of this than the crypto industry. Let us remember, we do not have a perfect political system. The crypto industry has all the money. They make money by literally making money, and they spend hundreds of millions of dollars trying to influence Congress. Those who in favor of effective tax enforcement do not have a PAC, and the people who enforce our sanctions laws do not have a lobbyist. The crypto industry is very clear. They regard the United States government as a criminal enterprise, and they promise that they will do whatever, using a very effective tool to defeat efforts to enforce our tax laws and our sanction laws. They say that the role of the U.S. dollar, which benefits America tremendously in terms of economic and national security power, is illegitimate, that the U.S. dollar does not deserve this role, and that they wish to partially displace this. And then they've come up with a mixer technology. Mr. Stark, other than mixing up law enforcement, is there any legitimate purpose for a mixer?
No.
I would point out that for hundreds of years, we have outlawed burglary tools. Burglars would dream of burglaries as successful as we've seen in the crypto world. We are told, on the one hand, that enforcement takes too long and lags, and then we're told that that we ignore due process. You can't have due process and speed. usually at the same time. But I look forward to working with my Republican colleagues on legislation to perhaps skip some of the enforcement processes to make it a faster approach. Well, Mr. Stark, are we over-deterring beneficial actions in our capital markets?
I don't think so, Congressman. Taking crypto, for example, if the SEC weren't out there deterring crypto and bringing all of these cases, by the way, most of which, in fact, I would argue all of which they've won, if the SEC weren't out there, investors would just lose more and more money, and there would be tremendous systemic risk to U.S. capital markets. Remember, for these crypto companies, there's no regulation whatsoever, no audits, no examinations, no net capital requirements, nothing.
I would point out that whether the SEC wins or loses means how the courts apply a Howey case from the 1940s dealing with oranges. That is a peculiar way to determine how much we should regulate crypto. I applaud the SEC and their legal team in gaining jurisdiction by applying that case. But Congress should vest all authority, or should vest full authority in the SEC to regulate crypto. No investment area has been the subject of so much investor fraud. No investment promises to undermine the role of the U.S. dollar and to defeat U.S. law enforcement. And yet, Congress sits back and lets the courts decide whether the SEC has jurisdiction by counting oranges in an orange grove in a 1940s orange grove that I'm sure is a suburban subdivision now. So I would just say that the SEC certainly has not gone rogue. We need definitive standards, and those standards need to be tough enough to deal with those who would cheat investors, and I yield back.
Gentleman, time's expired. The chair now recognizes the gentleman from Oklahoma, Mr. Lucas, for 5 minutes.
Thank you, Madam Chair. Since the Biden administration could not implement its climate agenda through the legislative process, it's turned to the agencies to push climate policies on their own. The SEC is on the front lines of this effort by pushing to mandate climate disclosures on public companies and to embolden climate activist shareholder proposals. The SEC also created a task force focused on climate and SEG issues with an enhanced focus on climate-related risk in the SEC's examinations. The SEC's Division of Enforcement should have a straightforward function. If security laws are violated, the Enforcement Division takes actions to make investors whole and to punish the bad actors. If you break the law, you pay. Unfortunately, recent high-profile climate-related enforcement actions have illustrated that the SEC plans to use enforcement action as an instrument of policy. Now, it's not just public filings such as 10-Ks that the SEC is assessing. It's voluntary sustainability reports, it's self-published climate information on a company's website, and it's even public comments from a company's CEO. The SEC aims to use enforcement cases to signal to the markets the type of climate-related policies and procedures that are acceptable. Now, this runs the risk of irreversibly harming the SEC's reputation and damages the willingness of companies to stay in public markets that everyday investors benefit from. Mr. Vulmer, could you discuss from a high level the harm to public markets if the SEC's enforcement arm is called into question? What's going to happen when somebody jerks their chain over this?
Yeah, well, the enforcement function is really important to the smooth and efficient operation of the capital markets overall. But because you need to have the rules set out in advance and clear to people, which you've recognized, but they have to be enforced as well. So all of us, I think, at this table, believe in a strong enforcement function. The problem is the rules have to apply to the enforcement agent as well, to the law enforcement agency. And when people begin to doubt the reliability and the merits of the enforcement cases, it generates and builds disregard for the law, which then in the longer term disserves the capital formation function. So it's an important, enforcement is very important, but it needs to be done in a right way.
Mr. Morgan, from the perspective of a small issuer of securities or a private company looking to raise public funds, what are the risks of having an unpredictable enforcement arm of the SEC that may shift focus from one administration to the next?
The risks are perversely an incentive to disclose less information. So you pointed out that often liability will hinge on something that's not in a 10K, it's in an offhand comment made by a CEO, or it's in policies that are published publicly. The perverse incentive there is, and it's unfortunate, is that there will be few of those disclosures, so that there is less of a hook for the SEC to hang liability on after something happens that's unpredictable.
Shifting to another topic that's captured the attention of Congress and the regulators, artificial intelligence. The SEC recently announced settlements with 2 investment advisors that were accused of misrepresenting their use of AI. A new term was given for this. I believe it's called AI washing. We, of course, want capital markets to be adaptable to new technologies that allow the United States to maintain the most robust capital markets in the world. At the same time, we must make sure the emergence of new technologies isn't a cloud cover for firms to mislead the public and investors. Mr. Vulmer, in your view, how should the SEC and Congress approach the issue of AI washing?
The 2 cases that you mentioned are really fairly straightforward investment advisor cases and didn't really break any new ground. They were touted by the SEC as to be about AI washing, but the cases were not really AI cases. They were about what the defendants said about their use of AI, and in fact, the cases really were non-AI cases. So I think that the SEC should be careful not to stray from its conventional established boundaries, and their effort in the AI area needs to be to make sure that companies or investment advisors are using complete and accurate disclosures about their use of AI.
My time has expired, Madam Chair.
Gentleman yields back. The chair now recognizes the gentlelady from California and the ranking member of the full committee, Ms. Waters, for 5 minutes.
Thank you very much. Mr. Stark, this month, in a significant win for the SEC, a U.S. District Court judge ruled that the agency could proceed in its case against Coinbase. The agency had previously alleged Coinbase of illegally operating as an unregistered securities exchange, broker, and clearing agency. The court held that because some of the tokens traded on the Coinbase platform met the definition of investment contracts, the SEC can move forward with this case. So in an 84-page opinion, the judge asserted that, and I quote, the crypto nomenclature may be of recent vintage, but the challenged transactions fall comfortably within the framework that courts have used to identify securities for nearly 80 years, quote unquote. Now, what are your thoughts on this opinion? Do you agree that the SEC has clear legal authority to regulate cryptocurrencies as securities and crypto platforms as securities exchanges and brokers? And finally, how is the SOC exercising its authority? I just heard that they should stay within their boundaries. Would you share your thoughts?
I agree they should stay within their boundaries, and this is precisely within their boundaries, Congresswoman. I looked at the Coinbase decision, the motion to dismiss, and what's so remarkable about all of these crypto-related decisions is these judges have taken extensive time to explain what's pretty obvious to most securities lawyers, probably to all securities lawyers, that when it comes to these crypto assets, however you shape them, they're obviously securities. The 33 Act was created after the 29 crash. And it was set up to say, look, if you're selling securities, selling investments to people, you're going to have to register. And then the 34 Act said, look, if you're an intermediary and you're transacting for people in securities, then you have to register. And the 40 Act said, if you're advising about securities or you're bundling these securities, then you have to register. So these are not very complicated ideas. It's the ideas to protect individuals and protect market integrity. And time and again, if you look at all these decisions, and I've read every single one of them, you're talking about almost 200 SEC cases that are crypto-related. And you have the LBRY case, the Kik case, the Terraform Labs case, where judges have really gone out of their way to present exhaustive analyses about why these tokens, or whatever you call them, why this mathematical formula of digital asset is a security. And I think it's pretty obvious to these judges and pretty obvious to most securities lawyers as well.
Thank you very much. I also heard, I think that's Mr. Rowland, Foreman say that we should be careful about penalties, that we're charging too many penalties. Too many people inside the SEC have the ability to establish what the penalties are. Have any thoughts on that?
Absolutely. I agree with Mr. Vulmer that when it comes to penalties, the statutes that are written talk about violations. But I find it surprising that this committee is talking about things like violations of SEC statutes. Look at the recent sentencing of CZ in the Binance scandal. That Binance paid a $4.3 billion fine. That's, I think, the largest in history with respect to their anti-money laundering violations. There's now a monitor at Binance with the most robust monitorship I've ever seen in my 35 years working in this industry. And what are these money laundering, what do they mean? Why do we have these? Because of all these dire externalities of things like crypto, ransomware, child pornography, human sex trafficking, and sanctions evasion, terrorist activities from rogue nations. That's why we have these AML, important AML requirements, and yet CZ was sentenced to 4 months. I'd much rather see a hearing on that. Can't we do something to meet for someone like CZ to go to prison for a longer time than 4 months and come out with billions of dollars? This idea that, you know, better to beg forgiveness than ask permission, it's become a crypto rhetorical staple. And so when I look at these sentences, that's what I feel like we should be talking about, Congresswoman.
Thank you so very much, and I yield back.
Gentlelady yields back. The chair now recognizes the gentleman from Texas, Mr. Sessions, for 5 minutes.
Madam Chairman, thank you very much, and I find this hearing that you have initiated very interesting. And the comments also, I would just say, I find it also interesting, as the gentleman talked about interesting things. I find it interesting that a crypto fraudster would meet with the SEC chairman. I found that very disturbing. Mr. Eckert, I'd like, because I think you've written a lot about the administrative law judges and their roles, where the SEC refers to them to do much of the dialogues that take place, including being the oversight, the judge, and the jury. I've got 5 minutes, 4 minutes, 10 seconds. Can you talk about this?
Sure. The SEC's Administrative Enforcement Forum has existed for a long time, but until 1990, its use was largely to essentially vindicate the SEC's what are often called public rights. So think about, like, the FCC regulates broadcast licenses. We license new issuances of securities, market participants, et cetera. And their use of that enforcement authority in that forum was really to administer the registration processes and the like. Beginning in 1990 and then much more with Dodd-Frank, enforcement actions as such were being brought.
So was Congress non-specific in this in this Dodd-Frank legislation?
Yeah, in the Dodd-Frank legislation, Congress conferred authority to the SEC to fine unregulated individuals, unregulated companies in the administrative forum for the first time.
So you think, do you think that we should come back as Congress and look at that?
I do.
What might be that potential balance that, because we don't want to harm the SEC, we want them to do their job, but I think the chairwoman talked about fairness and trust as a regulator, and I would agree with her. Where would that fairness and trust reside?
I think the biggest concern was that somehow, without this administrative forum available to the Enforcement Division, they would be overwhelmed, or courts would be overwhelmed. In the last 2 or 3 years, they haven't had the ability or have chosen not to use it, and they are marching along just fine in terms of their enforcement docket. A removal right would allow for people to assert private rights that, as we expect in federal cases. They could elect to remain in the administrative forum, much like people consent to magistrate trials.
So there could be, once the enforcement action is taken, then that adjudication, if that's a correct term to use, the adjudication then would be up to an agreement that the person who was being charged could go to federal court or the administrative procedure.
Exactly. There may be reasons why a respondent would choose the SEC's forum. It's faster. There's fewer rules. There's less discovery. That may be an advantage. But the respondent could elect to remove to federal district court and enjoy the rights under the federal rules of civil procedure and evidence.
Yeah, great. Mr. Morgan, I want to move to one other question that dealt with, I think, something that you spoke about. That is the length of time that it takes the SEC to even acknowledge a complaint and to resolve that. Can you talk to us about what that balance and fairness that the chairwoman talked about, fairness and trust as regulators, what should Congress take away from how that would be?
Well, so the length of time that it takes to conduct an investigation is just too long for most ordinary Americans to be able to survive. And so there is a real need, just even by people who are never accused of anything, to speed this process up. There was a provision in Dodd-Frank that required the SEC to bring an action within a certain amount of time of giving a so-called Wells notice. In my experience, that provision, that requirement has by and large been ignored. So putting more teeth into that requirement would be very helpful.
Stated a couple times, but when my father was the director of the Federal Bureau of Investigation, he became aware of that the Bureau would start an investigation, maybe move all the way through that before they charge someone. And he found, and I think initiated, that if there's competent legal counsel against someone they're charging or begun that investigation, the Bureau should move to that competent legal source to resolve the matter, not to carry it on for forever. And I think it would exist with SEC lawyers. Madam Chairman, I yield back my time. Thank you very much.
Gentleman's time has expired. The chair now recognizes the gentleman from Georgia, Mr. Scott, for 5 minutes.
Thank you, Chair Lady. I appreciate that. Mr. Eckert, my concern is this. If we force through overly complicated rules like this, we risk having more small businesses and more startups losing their ability to raise money, to raise capital. Do you agree?
In terms of the removal right from administrative proceedings, I think, in my experience, particularly the small businesses prefer a federal court venue because they're used to that in their ordinary course of business commercial litigation.
So do you generally agree that improvements to market transparency, standards by the SEC, should provide participants with benefits while also balancing the costs of operating in this space?
As a general principle, I have no objection with that at all.
Now, I have some information here from the MSRB, and they found that in 2022, approximately 73% of the trades in the municipal securities market currently subject to the 15-minute reporting time frame were reported within 1 minute of execution. It also found that 97% of trades were reported within 5 minutes. So while it seems that the 1 minute reporting time frame is already happening, a number of comments have raised concerns with the technological feasibility of the proposal, arguing that subjecting the fixed income market to any shortened requirement was a misguided approach. So, Professor Eckhart, can you explain how fixed income markets, including the municipal security markets, differs from equity markets, particularly when it comes to technology, manual processing trades, and automation?
Sure, this takes me back a while, but yes, the bond markets and the equity markets are very different. The bond markets tend to be decentralized, still over-the-counter markets. I have represented a number of clients in this area. Over the years, what the SEC and FINRA and the MSRB have been doing is to try to, what we would call, equitize the debt markets a little bit. And so you see in terms of trade reporting and transaction reporting, increased demands on the fixed income side. There are always concerns with incremental increases in trade reporting and shortening the times that you will chill liquidity, which is a big concern in the debt markets.
Yeah, well, it's very important. Why is it important for regulators to consider certain types of manual trade exceptions with a shorter time frame being implemented in a phased manner?
I'm not sure I'm familiar with that particular requirement, but when you have manual trade processing, that usually takes longer. So you still have, even in some of the backwaters of the fixed income markets, actual paper order tickets and manual trades reporting.
Yeah, you highlighted manual trade exceptions. Does a manual trade exception strike the appropriate balance between shorter reporting timeframes and avoiding disruptions to the marketplace? And is it consistent with previous regulatory authority?
Yeah, I can't remember this particular one. This may go back some years, but I think what you have in the municipal bond reporting area years ago was there was really technological issues with transaction reporting. Firms didn't have front-end systems that connected directly with FINRA or the MSRB's trade reporting system.
Well, in your estimation, are we doing the right thing here with this rule, with this approach? I'm somewhat concerned about when we have these overcomplicated rules. Are we really taking into consideration the impact that it has on the ability to smaller firms and to raise the necessary capital?
Yeah, we may be talking about two different things, but I don't think I've ever advocated too rapid a trade reporting system for small firms, or for my representations in this area have been on behalf of the Trade Association for dealers.
My apologies, but the gentleman's time has expired. I'm so
Well,
sorry,
thank you
Mr. Scott.
Thank you.
If you would finish your reply in writing, that would be great. Thank you so much. The chair now recognizes the gentleman from Michigan, Mr. Huizinga, who is also the chair of the Subcommittee on Oversight and Investigation, for 5 minutes.
Thank you, Madam Chair, and I want to appreciate your time for the witnesses here. Mr. Morgan, I want to say thank you for sharing that story of both Eric and Joseph and the work that you're doing to represent those who may not have the means to represent themselves. And it does sound egregious from where I'm sitting as to some of those actions from the SEC. The SEC's enforcement functions serves an important role. Nobody doubts that. But they're supposed to be instilling confidence in our markets so that investors may safely invest and save for their retirement. However, in the debt box case, a judge sanctioned 2 SEC lawyers for committing a, quote, gross abuse of power. According to reports, the abuse of power is so egregious the 2 attorneys resigned after facing threats of termination. Given your experience, Mr. Morgan, as a former SEC trial attorney, What is your reaction when you hear what these SEC attorneys did and how they acted?
My reaction is the process needs to be changed. I don't think it's a problem with the ethics of the SEC enforcement staff in general. That's clearly not in question. The problem with the debt box case is they proceeded by way of a so-called ex parte hearing where the defendant's counsel were not present. There may be extreme instances where that's an appropriate way to go, but the entire problem came down to the fact that the defense counsel could not point out the obvious. These things the commission attorneys are saying are not true.
Yeah. All right, Madam Chair, in light of the debt box case, I would like to enter into the record a letter I sent to the SEC's Office of Inspector General, which asks them to perform an audit of the agency's performance review process, which ultimately supports their own recruitment and retention.
Without objection.
Thank you. Mr. Vulmer, Mr. Eckert, I'm going to turn to you. Since Chair Gensler took the helm at the SEC, his enforcement division has used the Wells process, and I think, Mr. Morgan, you had just mentioned that as well, at an astonishing rate, especially when it comes to digital assets. Yesterday, it was Robinhood. Before that, it was Coinbase and a few other notable firms. Regardless of how much he wants companies to, quote, his words, come in and register, I think that we can all agree that that isn't as simple as that, which is why I support Chairman McHenry and the committee's work to provide clarity through the legislative process. But in some cases, those Wells notices just sit out there. Mr. Sessions talked about that with his dad's experience with the FBI, where you see the SEC issuing these, but doesn't pursue litigation. But they also won't close them out. So obviously, if there is a company that receives one of these notices, you're left in limbo, and ultimately it impacts decisions on where you would take the company. It certainly impacts shareholders and consumers. So Mr. Vulmer, and then I'd like to hear from Mr. Eckert here quickly. First, do you believe the SEC is abusing the Wells process? And two, how does this divert from the common practices and operations that the SEC has used in the past? And by the way, you had said something, conventional and established boundaries. I'd like to add in another word. How about legal boundaries? Because they've been getting their, you know what's handed to them and by the courts as of late. So please, for you to address that.
Well, I agree with adding legal. The Wells process is basically a good process. And in fact, your criticisms, I think, don't go to the Wells process itself. It goes to what happens within the commission staff after I'm going to call them a defendant. They're not a defendant yet, but I'm just going to call them that. Sends in their Wells memorandum, which is trying to talk the staff out of a case. That's where problems can occur. The staff can just go silent and can go silent for a very long time. And that's when the problems you identified can occur.
I don't think anybody has a problem with the Wells process per se of issuing it. It's then what happens, right? Mr. Eckert, you want to weigh in on this?
Sure, it tends to become public. It's not a public event, but there are pressures on companies.
Would this be maybe naming and shaming? I mean, that's another phrase that might be worn out, like more cowbell.
Yeah, it can work out that way. I think a lot of times companies just have pressure to disclose, to make disclosures. It may be that counterparties, vendors, individuals make disclosure. It does trigger registration amendments for regulated firms, so it gets public that way. One of the good things of the Dodd-Frank provision that put the 6-month tail on it was it forced engagement earlier. So we have practices now that are pre-Wells, and I think the more an investigated entity gets to engage, the better.
And that's going to lead into this, and we're going to need to get written responses. But the FEC enforcement staff decides not to move forward with litigation. The required process and timeline for termination doesn't seem to be adhered, correct? And we can get those answers in writing if that's all right.
If the gentleman witness could respond in writing, I would appreciate it. The chair now recognizes the gentleman from California, Mr. Vargas, for 5 minutes.
Madam Chair, thank you very much. I think this has been a very good hearing. I appreciate it very much. In fact, up to now, I think it's been eminently reasonable, very much so. I do want to, and there's different opinions, and that's fine. I think that's very important. I do want to ask a question that I try to ask most of the witnesses that come before us, and that, how many of you believe in climate change? If you could just raise your hand. Good. I mean, the reason I'm so pleased with that, when I started politics 20 years ago, one person would have raised their hand. And now, thank God, even the witnesses on the other side are raising their hand. Mr. Morgan, you provided two compelling examples of people who I think probably did get hurt by the system. I don't know all the facts, but they seemed quite compelling as you provided the information, and I assume that there's true. But also there were other statistics that were thrown out showing how many enforcement actions there are. There's so many. I have to tell you, the law gets it wrong sometimes. I mean, all the way up to innocent people being convicted of murder, and us finding out later with better evidence, scientific evidence, finding out the person was innocent and he or she's been held in prison for a long time. So of course we make mistakes. That happens. But you gave two compelling examples. But you also saw all the statistics that generally the SEC gets it right. Is that correct or is that not correct? And go ahead and answer that.
Yeah, no, that's not actually correct. I think the statistics you're referring to refer to settled cases, which the SEC puts in the win column. Having represented a number of people who felt that the choice between settling or litigating was a Hobson's choice, that they could not afford to litigate, results in a quote-unquote win when they settle. And I think that the cost of confronting the SEC is exorbitant for ordinary people. And so what ends up happening is you get a huge win rate because the SEC threatens financial and professional ruin.
Yeah, and in fact, you said that's one of the reasons you set up your firm. I think it's a noble thing, and again, that's why I think this is eminently reasonable. Mr. Stark, would you disagree with the amount of cases that it gets wrong? Yes.
Absolutely. I've worked at the SEC for almost 20 years in the enforcement division, including 11 as chief of the Office of Internet Enforcement, and I think every case we ever did in the Office of Internet Enforcement, we got right. And I think majority of staff would feel that way.
I bet you got a couple wrong, just to be honest with you. I mean, been around the courts long enough, but I'm sure you think you got them all right. They always do, but which is fine. I mean, that's one of the reasons we have these discussions. And I think there should be some zeal on the part of the people who are at these whether it's law enforcement or SEC. So I think that that's appropriate. And Mr. Morgan, I don't want to pick on you, but you also said something else that was quite compelling to me, and that is, and I want to quote you because I think this is correct, that markets are entitled to transparency. I think you said that. I don't want to put words in your mouth, but I believe that that's what you said, and I agree with that. So I look at the information of ESG, and I see that some on the other side and some states don't want that information to be transparent. You also said there should be, others said that there should be, I think you did actually, there should be uniform policy and not a case-by-case basis enforcement. It seems like that's what the SEC is trying to do with its climate rule, is it not? Mr. Morgan, I'll let you answer.
I do prefer rulemaking in this context to piecemeal litigation over the issue. There's no question. That doesn't mean that a particular rule is the right way to go. The benefit of rulemaking is we can all look at the proposed rule, we can criticize it, we can comment on it. Unfortunately, with regard to that specific rule, the climate disclosure rule, the final rule changed substantially from the previous versions, and so the public was denied the opportunity to comment on
Mr.
that.
Stark, would you agree with that?
Yeah, I think that, when you're looking at rules and the SEC, for example, in materiality.
And I'll only give you about 20 seconds because I'm going to cut you off.
Okay. Well, when it comes to materiality, for example, in the area of cybersecurity, you can use the materiality standard or you can use the specific rule that the SEC has come out with. I think the materiality standard would be a lot better than the rule because the rule seems kind of random to me in requiring a disclosure in 4 days. So that's how to answer your question quickly.
No, that's fine.
I think Mr. Morgan is right, though.
But I am going to cut you off as I promised. And the reason for that is at the beginning they said that, we need to enhance public trust of these institutions. The public trust in our institutions are falling. They are. When you call these institutions fake, when you have the former president, today going before a court with pornography star, all this stuff, of course, our institutions. So we have to change, and that's why I think this hearing was so good. Thank you. I yield back.
Gentleman, time's expired. The chair now recognizes the gentleman from Pennsylvania, Mr. Muser, for 5 minutes.
Thank you, Madam Chairwoman. Thank you all for being here. So the SEC, of course, is tasked with safeguarding investors, ensuring fair markets, promoting capital formation. Current SEC leadership seems to have strayed from at least 2 of 3 of these objectives, focusing instead on aggressive enforcement and rapid rulemaking. And totally neglecting, in my view, market feedback, and its so-called safeguarding is backfiring, and the data supports that. At a hearing earlier this year, David Burton from the Heritage Foundation, I asked to rate the SEC's helpfulness to small businesses and investors on a scale of 1 to 10. He rated Chair Gensler's SEC a 0 out of 10, but suggested that the SEC could reach a 9 out of 10 if it prioritized meaningful reforms. Tom Quadman from the U.S. Chamber of Commerce echoed these concerns, criticizing the SEC for repeatedly undertaking rushed, unworkable, and politically motivated rulemakings and undermine investor protection and reduce the competitiveness of American capital markets, which is the whole mission of the SEC. So there's many examples, SPAC mergers that took 450 days to come together, SEC Enforcement Division's Climate Task Force, its extensive sweeps on cybersecurity violations in more than 25 firms with, just throwing a wide net without any real detail. And all of this ESG ideology, that's wonderful, but really, what's next? What foods, what companies that make the most healthy foods that are best for the American people, the safer cars, that's where the investment company should be directing funding. I mean, what's really the difference? I mean, if a car is less safe or more safe in the view of the SEC, of course, they should be the judge here as they attempt to be on directing the fiduciary responsibilities of investment firms for investments. It's outrageous. What about baseball? Because don't invest in hockey because hockey's too violent. I mean, what we're talking about here are things that are way out of the realm of the SEC, and it seems that they somehow feel that burdening industry creates a safeguard to investors. And I spent enough time in business to know that that is the furthest thing you want to do for innovation, for lowering costs, for deliveries, for all the things that the consumer demands in a competitive marketplace. But then again, when you don't respect a competitive capitalism, you just think that these burdens have no bearing whatsoever, and yes, they do. They drive a lot of business to China, and they drive a lot of business elsewhere in the world who are allowed to be more competitive under the realm of Gary Gensler's SEC. So, Mr. Vulmer, how should the Division of Enforcement measure its effectiveness? It seems Chair Gensler touts record fines and number of enforcement actions. Do you believe there is perhaps a more balanced metric to use?
I think they need to get away from those measurements to a very large extent, and I think the agency as a whole can achieve the goal of greater compliance by a variety of other mechanisms rather than enforcement. And right now, enforcement measures itself by the number of cases, the amount of fines, the amount of disgorgement. They really ought to be measuring the number of the increase in compliance, which of course is extremely difficult to measure, but that ought to be the attitude at the Commission overall.
Yeah, absolutely. And Mr. Record, I'm going to ask you this. In the remarks of the SEC Commissioner Peirce at the SEC Speaks last month, she stated that market participants want to have conversation with their regulators, but do not and cannot because of fear of enforcement. What do you think about that environment?
Well, I think to the extent that fear is widespread, and you certainly can observe it from time to time, which is one of the reasons why firms act through trade associations, it goes to the heart of why we have administrative agencies. We want them to develop expertise. We want them to understand emerging and current market practices, new products, trading strategies. We want them to be able to weigh in with their expertise to help guide that which needs to be fostered and to stop that which needs to end.
Okay, thank you. I'm out of time, Madam Chair. I yield back. Thank you.
Gentleman yields back. The chair now recognizes the gentleman from Illinois, Mr. Caston, for 5 minutes.
Thank you, Madam Chair. Thanks to all for being here. I must say I find this hearing sort of intellectually fascinating because it's the crux of what almost all of our conversations about the SEC boil down to. That is the role of the SEC to provide democratic access and robust capital markets, or is the role of the SEC to protect investors? And there is a tension there, and if you push too hard in one direction, it compromises the other, and vice versa. I personally tend to come down on the side of investor protection just because there has always been money in being on the right end of an information asymmetry in markets. and the SEC is the sole entity that can enforce that, but I think it's a healthy debate. I want to frame that debate a little bit for all of you, just with a hypothetical, if you'll allow me. You all seem like fairly sophisticated folks. I want you to imagine that your investment advisor comes to you and says, I've got a new company that just went public, and I'm suggesting you invest in it. But before you make the decision, I want to let you know that they went public with a not very well-known auditor, and that auditor has achieved poor ratings from the PCAOB in the last 2 years of reportings. The PCAOB got a little nervous about him and did a random sample and found material deficiencies in every audit they sampled. They found they relied on management to state revenues. They never checked it. They didn't test the various income declarations. They didn't test anything about fair asset valuation. If that's all you know about the company, are any of you willing to do more diligence, to do the investment, check the financials? You think that's a good place to put your retirement income? Anybody?
I would say no. And I would say...
Well, I don't mean to be cute, but I'm saying that because now, so you tell that to your advisor, and your advisor says, okay, but there's something else I should tell you. The majority shareholder in this company has an equity kicker based on short-term stock prices, and they've been convicted in court of financial fraud. Does that make you feel more comfortable about the investment, or are you walking away at that point? This is not a complicated question. I'm not trying to gotcha. I'm just I asked that because I just described Trump media. All right? And B.F. Borges, who's now been found, who's been kicked off, and PCAOB did all that. And the fact that rich, unethical people can corrupt members of Congress means that question is going to be political. It is noteworthy that on this committee, the oversight arm of the Financial Services Committee is not investigating Trump media, is not investigating Donald Trump. I don't expect they would. That's a political question. But it's why we need the SEC to be robust and investor-focused, because as long as rich, unethical people have a way to influence the legislative branch, there's going to be a lot more power held by rich, unethical people in this society than by mom-and-pop investors who want access to those markets. And all of that brings me to crypto, Mr. Stark. You mentioned in your testimony that crypto has evolved into a killer app for criminals. I don't think you said it's evolved into a killer app for investors. I've got some similar concerns, especially with respect to Tether and some of the reports that, as a stable coin, it's helping to fund Russia's war machine. The overwhelming majority of the crypto funding that Hamas has used has been through Tether and the Tron network. I wonder if you'd comment on how you would suggest we address Tether, and then specifically how we should think about anti-money laundering provisions and mixers in any stablecoin legislation.
I think you raise a great point about Tether, and you talk about it in the context of audits. You mentioned how important audits are when it comes to any sort of investment. And when you ask the question, would you ever invest in a company that was being audited by an auditor I'd never heard of, or wasn't, or was somehow not a great auditing firm? Of course I wouldn't. And that's exponentially true for Tether. Tether claims to have some sort of audit, but it's essentially a satellite snapshot of a days of its events. What is so hard about auditing Tether that they can't, and this is a critical part of every single crypto investment. And they've been saying for years, we're going to get an audit, but they haven't. What would be so hard? Any of us on this panel could conduct that audit. You're just going to look and see whether the tethers are actually backed by real U.S. securities of some sort.
So I'm almost out of time, but I just want to flag myself and Mr. Sherman, Mr. Foster, Mr. Cleaver are introducing a bill this week specifically to clamp down on mixers and to say that until we've studied and have a good audit trail, the presumption should be that these are money laundering channels. Let's go through, get that cleaned up and fixed it, and hope to get
Absolutely.
broader support to bring it forward. Thank you. I yield back.
Gentlemen, time's expired. The chair now recognizes the gentleman from Wisconsin, Mr. Steil, for 5 minutes.
Thank you, Madam Chair. I feel like some of my colleagues might feel like we're in the Financial Digital Assets Subcommittee, not the Capital Markets Subcommittee. But let's dive in, because I'm really concerned about what the Securities and Exchange Commission has been doing. Mr. Morgan, your testimony, you wrote about how the SEC's regulation by enforcement approach hurts entrepreneurs, sales professionals, and in particular, their customers and retail investors. Completely agree with you. I want to dive in, if I can, specifically as you wrote about forum shopping. And so the SEC, as you note, has this ability to go and choose a forum that's favorable to them in the process, at the detriment of often retail investors or salespeople. Can you talk about kind of the uncertainty that creates, and whether or not Congress should be looking at adjusting the rules of the road in that regard?
Sure, great question. So the SEC can forum shop in more than one way. It can choose geographically where to file a suit. It can forum shop temporally over time. So in the case of my client Eric, that's what happened. The SEC lost in the DC Circuit Court of Appeal, but then the SEC felt unconstrained decades later to bring a case in Los Angeles.
So does this mean that the other side has an unfair?
It is
position?
unfair. And not only is it unfair, it harms investors, it harms professionals. They don't know. They have to live with decades of uncertainty, just waiting for the SEC to bring another case in a different jurisdiction.
Let me jump over, if I can. Thank you very much. If I can jump over to you, Mr. Vulmer. Talking about kind of fairness, the SEC's administrative courts, do the administrative courts undermine the public's trust in the Securities and Exchange Commission in particular as it relates to their enforcement actions?
Oh, I think significantly, to the extent people understand the differences in process between the federal courts and APs, yes.
And what should Congress do to strengthen that? Confidence in it?
I think Congress ought to eliminate the use of administrative proceedings and require all enforcement cases to be brought in federal court. That's my preferred outcome, and second best would be a removal option for the defendants that would be unqualified and unreviewable. So a defendant can just move an administrative case to federal court.
Thank you. Let me come back to you, Mr. Morgan, because you noted you do some pro bono work. What type of clients would require pro bono work from you? The largest companies in the world, or is it maybe somebody else?
The vast majority of people facing the SEC Enforcement Division are ordinary people, and those are the people who need pro bono representation. Often, as in the case in our clients that I talked about today, they're not accused of fraud, they're not accused of harming investors, they're caught up in the SEC machinery for having violated things on it.
Is this thinking of somebody maybe who's an entrepreneur or a sales professional? Would that be a description of somebody that might require your pro bono expertise? Not J.P. Morgan or Goldman Sachs or somebody with a massive legal operation inside the company. Is that a fair description?
That's an exact description of our clients, yes.
Okay, so in one of those clients comes in, the Securities and Exchange Commission, what kind of resources do they have and an ability to bring to bear in that case?
Well, it's a nearly infinite number of resources. They can add staff attorneys. They've got professional economists and accountants, all sort of who can act in sort of an expert capacity.
So let me go back to forum shopping. Say the Securities and Exchange Commission then engages in a form of forum shopping. What does that do to the defendant?
Well, it's terrifying. You think an issue of law is already settled. It's not. So you go about your life thinking you're obeying the law, and the SEC takes a contrary position.
If you were not doing this pro bono, what would the legal fees look like for one of your defendants?
Just to get through an investigation before you step foot in court, hundreds of thousands of dollars, if not millions.
And so what is that? Let's assume your pro bono services are not available. Defendant comes in. What would the likely advice of legal counsel be to that defendant? Would it be to settle the case with the Securities and Exchange Commission, or would it be to spend hundreds of thousands of dollars just to get through phase one?
Settle, absolutely.
And would you agree with that? I see you nodding, maybe, Mr. Eckert.
Absolutely.
And would that be in line with you, Mr. Vulmer? And so, is it fair to say that the SEC brings overwhelming power to bear on some of these? And we see settlements through this. We see enforcement. We see legislation being made in effect, right, through the SEC, through enforcement actions, and we don't have these court cases going all the way through, and they're not even all the way out in a full court.
It's certainly true for individuals, as Mr. Morgan was saying. they have overwhelming power and pressure even on the JP Morgans and the Goldman Sachses of the world.
Thank you all for being here. Madam Chair, I yield back.
Gentleman yields back. The chair now recognizes the gentleman from North Carolina, Mr. Nickel, for 5 minutes.
Thanks so much to our witnesses for being here for today's very timely hearing. We're watching the SEC's regulation by enforcement play out in real time. After offering crypto on their platform for 6 years, Robinhood was just served a Wells notice, meaning that they should expect an SEC enforcement action very soon. Unfortunately, that just seems to be the cost of doing business for a US-based crypto company right now. Robinhood, for example, has publicly stated that it has heeded the chairman's call to come in and register, but to no avail. They've gone out of their way to delist products on their platform just to play it safe. Other countries view this hostile environment as really an opportunity to eat our lunch, and we see US firms packing up their laptops and heading overseas. The United States needs to remain the global financial leader, and we need an SEC willing to protect consumers without discouraging innovation and being overly punitive. Chair Gensler maintains that there's clarity on what is and isn't a security, but it appears that the only way to actually find out is to endure an enforcement action. On Squawk Box this morning, Gensler said that many crypto tokens are securities, but refused to provide any specifics. That certainly is not clarity. We need clear rules of the road for the digital assets industry, and I'm scratching my head about what they really are right now. Mr. Vulmer, first question to you. What more can we ask of Robinhood to do other than pack its bags and head overseas?
They might yet be successful in talking the staff out of the case, although that is extremely unlikely. So the real solution here is what you've already talked about. The difficulty is that the SEC preempted this entire area for regulation on, and I thought I was going to get through this whole hearing without talking about crypto, but apparently not. With a pretty vague theory about its regulatory jurisdiction, and one I don't entirely agree with. So your solution is the right one. Congress needs to just draft some authority. It doesn't have to be for the SEC, but to regulate digital currencies in the way Congress thinks is the right policy. That would help the Robin Hoods of this world too.
Whether you love crypto or you hate it, as Democrats, we should want regulation. That's what we're talking about, regulating an industry. As the former SEC Deputy General Counsel, do you think, specifically back to crypto, that the SEC is currently providing regulatory clarity for the digital assets industry?
Oh, no, I don't think so at all. I think there are lots of crypto assets that do fall within the standard, what's called the Howey test, to be securities, but I think there are large groups of crypto assets that do not. And deep thought needs to be given to what does the country want to do about crypto assets, and do they want them to be regulated, and if so, in what way? And right now we're applying this blunt instrument of the securities disclosure rules and the securities regulatory system to this novel thing, which might have benefit and it might not. But we don't need the SEC to just preempt the field with its assertions of jurisdiction.
So being productive, trying to figure out a good path forward here, what specific changes, Mr. Vulmer, would you suggest to the SEC's enforcement strategies to foster a healthier balance between carrot and stick?
I think there needs to be more effort to achieve compliance in less costly ways and in ways that don't cause as much terror. So I think Mr. Morgan's two examples are really useful for everybody to think about. Those aren't cases that required enforcement actions against the two individuals. Even if the enforcement staff believed they had committed some wrongs or misconduct of some sort, there are probably layers or levels of ways they could have achieved a more juster, fairer outcome that's short of an enforcement proceeding.
Thanks so much. Madam Chair, I yield back.
Gentleman yields back. The chair now recognizes the gentleman from Massachusetts, Mr. Lynch, for 5 minutes.
Thank you, Madam Chair. Mr. John Reed Stark, I'm going to refer to a document that was submitted by the ranking member a little earlier. It's an article in Politico Pro dated last Friday, so May 3rd. The title is "The Law is Catching Up. Gensler's SEC racks up legal wins against crypto." So the article goes on to say that a string of legal victories by the Securities and Exchange Commission has jolted some of crypto's biggest players and shaken the industry as it strives for greater credibility in Washington. Judges have recently rebuked claims that the SEC lacks authority to police the market. Let's talk about the SEC authority. Explain or amplify the thinking behind the SEC's claim of jurisdiction in this case with respect to these securities.
Thank you, Congressman.
Tokenized securities, but securities nonetheless.
Agreed. Never in the history of the SEC has there been such an incredible and extraordinary use of various channels of communication to tell the world that these tokens are securities. Let's go through them. There's all sorts of regulatory pronouncements. There are now dozens and dozens, even close to 200 cases, and you can say some of those are settled.
Yeah. But you know, I don't want to interrupt you, but each and every one of those decisions lays out a roadmap. When people say they want certainty, if I was counsel for any of these firms, I would go through those 200 cases and find out where the pitfalls are, where the landmines are, and I would avoid those. Please continue.
Absolutely. I mean, it was Thurgood Marshall who stated in the case of Reeves, a Supreme Court case, that Congress painted with a broad brush. It recognized the virtually limitless scope of human ingenuity, especially in the creation of countless and variable schemes devised by those who seek the use of the money of others on the promise of profits. The securities laws were never written to cabin the scope. That was another expression that Justice Marshall used, and this case was long ago. I think that I find it amazing that attorneys will sit back in this situation and look at all these cases and still say, let's move forward with this. I can appreciate that Robinhood is a very different kind of entity than a lot of other entities, because Robinhood is a regulated entity and subjected to audit, examination, inspection. But when you're talking about the securities and you read these cases over and over again, and you listen to the SEC enforcement staff, and you listen during the Wells sessions, it seems as though the SEC has given everyone the clearest opportunity. And I think it was Chair Gensler who said, not liking the message is not the same as not receiving it.
Right. It just seems that this whole argument is, that crypto securities should have a whole different set of rules is absurd. I'm happy to see that judges in many different jurisdictions have come down similarly on this and have restated the Howey test and are holding fast to this idea that the SEC should in fact protect investors. Wouldn't it be, look, if let's just say we accepted their argument, the crypto argument, that crypto securities are different and it should have a whole different regime. They should be able to escape any prior legislation that addressed securities. Wouldn't the traditional securities industry just shift over, tokenize their securities, and then be able to avoid all of that legislation as well?
Absolutely, and that's what the crypto industry tried to do. They started with initial coin offerings. The SEC sued and said those are not securities. Then they moved on to simple agreements for future tokens, SAFs. The SEC sued, courts found they were securities. Then they went on to staking products. The SEC sued, courts found they were securities. Same thing with lending products, BlockFi and Celsius. The SEC sued, they found they were securities. They keep wrapping these up in some sort of new kind of paper, but it's really commonsensical, Congressman, when you look at these. People are investing on the efforts of others, and unless you want to repeal the 1933 Act and the 1934 Act and the 1940 Act, there's no other choice but for the SEC to act.
Thank you, Madam Chair. I yield back.
Gentleman yields back. The chair now recognizes the gentleman from Iowa, Mr. Nunn, for 5 minutes.
Thank you, Madam Chair, and thank you for our witnesses for joining us here today. Like many other members on this committee, even on both sides, we are seeing that unelected bureaucrats at the SEC are almost every day finding new ways to make life a lot harder for my constituents back in Iowa. Bureaucrats at the SEC sit in Washington, D.C., and they make decisions that have a direct impact both at Main Street, at my folks back home, my consumers, and ultimately American families. Never before has an SEC chairman been so well known, in fact, outside of Washington, D.C., and that's not something to be encouraged by. It's something that has a chilling impact. When the Director General noted that the SEC would recommend aggressive use of enforcement tools, we would never have guessed that it would go so far. And in addition to the amount of rulemaking that the agency at the SEC continues to undertake, the fear of SEC enforcement and the regime forces companies to hire additional FTEs. It's something I hear about every day in my office, whether it's new attorneys that need for compliance, whether it's audit officers that they're paying, or whether it's an outside compliance agency. These are costs that have a real impact. This disruption is made only worse when the SEC opts to use enforcement over rulemaking as a policy tool, something that is only stick and no buy-in with a good carrot. I understand the support needed for strong enforcement for bad actors, but treating everybody as a bad actor is no way to do business, and certainly not one that should come out of Washington. So I'd like to get started with Mr. Morgan. Let's talk about government regulation by enforcement. Many, including past and current SEC commissioners, have highlighted what I've just noted, that the practice of regulation by enforcement is chilling. Commissioner Hester Peirce stated that the SEC should avoid regulation by enforcement to be respectful to the due process of rights of the firms that we regulated, and I would say down to Main Street businesses. Mr. Morgan, would you please elaborate on the negative consequences when unelected bureaucrats eliminate the stakeholders' input in this process?
Happy to. So one immediate impact is we don't know what the law is. So long as the SEC is free to set its policy on a case-by-case basis, they can suffer an adverse ruling in the D.C. Circuit, for example, and yet come after your constituents in Iowa for the exact same conduct a year later, 5 years later, 20 years later. And so what that does is it discourages people from taking any risk in the capital markets, and that burden and that disincentive falls predominantly on people who are not traditionally part of the capital markets. So people are just going to stay away because they fear getting hammered by the SEC and being destroyed financially and professionally.
And so the negative consequence here is that not only are they trying to adhere to the law, they're trying to guess as to what the law might be in the future and taking on a large financial burden. Does that have a follow-on impact to the consumer when more money is being diverted from your mainstay business to trying to avoid future unforeseen regulation?
Yeah, I think the main negative impact there is that we just won't see the innovation. It just won't occur. People won't take the risk to introduce a new financial product. People won't try to raise money for small businesses because they fear falling afoul of the SEC. Even if they're not accused of fraud or investor harm, the consequences are devastating.
Thank you, Mr. Morgan. Mr. Ecker, I'd like to talk a little bit now on the innovation in AI, please. Specifically, the SEC plays a vital role in protecting investors, especially as new products emerge. That's something we want to see. However, many of us know that the SEC has also taken an extreme evidence that was recently sanctioned by a federal judge, saying that the SEC regulators' conduct towards a blockchain company constitutes a gross abuse of power. The direct result of what Mr. Morgan has just highlighted is that Debtbox ultimately paid the final price of going out of business because of SEC overregulation in this area and kneecapping the American economy. You would think that having lawyers called out by a federal judge as being grossly incompetent would force them to change their action, but in fact, despite significant legal setbacks in the digital asset space, the agency increased its digital asset-related enforcement sanctions by 50% last year alone. I would like to submit this article in projection to what some of my colleagues have highlighted that submit how these losses are piling up and the SEC's record is increasing despite this. Mr. Morgan.
Without objection.
Thank you, Madam Chair. Has the SEC regulation enforcement created a hostile environment for capital formation in America and put us at a disadvantage?
I think that was a question for me.
Yes.
Yes, it has. And I think we see the evidence of that by the number of people who would like to be involved with our fabulous capital markets, but who fear the negative consequences from the SEC's regulation by enforcement policies.
And Mr. Eckert, in our last minutes, how has this chilled the innovation coming out of our areas?
Well, again, as Mr. Morgan said, you see new products not coming to market where there's uncertainty. In the past, the SEC has been much more vigorous and willing to do things like entertain no-action letters that give comfort to new entrants than they are today, where they sort of sit back and wait.
Thank you, Madam Chair. I yield the remainder of my time.
Gentlemen, time has expired, and it looks like we have no more members left. I want to thank our witnesses for their testimony today. It's been a good dialogue and a good back and forth, and without objection, all members will have 5 legislative days within which to submit additional written questions for our witnesses to the chair, which will be forwarded to the witnesses for their swift response. I ask you to respond as promptly as you are able. This hearing is now adjourned.
Thank you, buddy.
What up? Why is everybody so quiet, man? We got Food Dog in the house. We got the great Tishnam in the house.
I don't know, but I thought we can hear the live stream, but I guess we can't.
I mean, if Casey's talking right now, we can't hear him.
No, he's quiet. I think they're all watching it on live stream, so I guess we can't hear on the YouTube side.
Yeah, we can't even hear him on the live stream, like on YouTube.